Welcome to Retiring Today. Ensuring your assets are protected and passed down according to your wishes is an important part of a comprehensive retirement plan. That's why today we're going to cover the difference between a will and a trust, protecting your spouse and family, power of attorney and medical directives, minimizing taxes, and some of those special occasions that can happen in life. Hi, I'm Molly Nelson here with Loren, Merkle, and Charlie Bottenberg. Loren is a certified financial planner, a certified financial fiduciary, and a retirement income certified professional. And Charlie is an estate planning attorney with Brick Gentry Law Firm. Loren, we've got Charlie here on the show today because you've been doing this for more than 20 years. It takes an entire team to put together a comprehensive retirement plan.
With something so important as your retirement, we're talking about one of the most exciting time frames of your life. You want to make sure that you get it right. And that's why we say when it comes to retirement planning, you get one chance to get it right. And so you do need a team of specialists working together on behalf of you to make sure that you have all the questions answered appropriately and you have a roadmap to help you make these decisions that you've never had to make before. And that's why here at Merkle Retirement Planning, we've created a proprietary retirement roadmap called the Retire Secure Roadmap. And there's 6 pillars that are involved with that roadmap. We have, of course, the lifestyle pillar. That's the fun stuff that people want to do in retirement. And then there's 5 financial pillars that need to be implemented to help people live that lifestyle pillar. So that's the income, tax, healthcare, investment, and legacy planning pillars. And that's why we work together with CPAs and estate planning attorneys to make sure that all of those pillars are working well together. And we've been working now with Charlie for 6-7 years. And Charlie works with a lot of the families that we serve and does a great job on the estate planning side. And I think it's important to note with the professionals that you choose to use, make sure that they primarily practice in that particular area. And that's one of the things I really like about Charlie is that's what he does, estate planning.
Yeah, and Loren, let's backtrack a little though, because I think sometimes, guys, when people hear the word estate, they get a little intimidated. They think, oh, estate planning is only for the ultra wealthy. But Charlie, you know for a fact that that's not really the case.
It's not the case at all. What people don't realize is that Iowa code has a default estate plan for all of us. Is that the same estate plan that you would want? Does it meet all the same objectives that you would want? Maybe, maybe not, but you're never going to know unless you sit down with somebody who practices in this area of law and spend some time and figure out, is that what I need? Or do I need something a little bit more comprehensive that maybe addresses some of the other things that we're going to talk about here yet today? Very, very, very critical to know what it is that plan is and, does it meet your needs?
And estate planning is one of the most misunderstood pillars of the 6 pillars. A lot of times when I sit down with somebody for the first time, I'll say, what have you done from an estate planning standpoint thus far? And their response is, well, I have a will. I set up a will. How long ago did you set that will up? 30 years ago. So they feel good because they did take steps at one particular point in time, but is that estate plan complete? Is that estate plan going to do what they want it to do when they do pass away?
Yeah, and that leads right into, let's talk about the will and the trust, because if you haven't set up a will since maybe your children were young and you're just trying to figure out who maybe would take care of them if you pass, that sure changes as you're heading to and through retirement. So let's talk about how the will could be used in that stage of life, Charlie, and the trust.
Well, sure, especially if you've done a will when you have small children and you've moved on past that phase, chances are that document's not going to meet your needs because your needs are different. A will is basically a legal memorandum instructing the court, instructing the fiduciary, your executor, the judge, to send your assets where the will says you're going to send your assets. But it doesn't do anything to help you avoid probate. It doesn't do anything, to deal with any other special circumstances that might have come up in the last 25, 30, current record is 60 years. It's a very oftentimes basic document. They can get a little more complex if you have a little bit more complex of a will with maybe a trust built into it. But, in their basic function, they are just instructions for the court to move your assets from point A to point B, which is often misunderstood as also helping you avoid probate, which a will does not.
Okay, so a lot of people then do maybe consider a trust. And again, I also feel like a trust feels like something for the ultra wealthy, but I've heard you talk about this before, Charlie. I mean, if you have a car and a home, you're already kind of bumped up into that net worth of maybe needing a trust.
Yeah, a lot of people don't recognize or understand that Iowa uses a concept called your gross taxable estate. It's an IRS term. Basically what it means is if you had access to those dollars, we'll call it 3 seconds before you passed away, and any life insurance beneficiary death benefit that you have, and any taxable or non-taxable gifts you made in the last 3 years, those are all rolled into your gross taxable estate. So it's really common for people to say, oh, well, I have an IRA or a 401k at work, and I have, my kids as the beneficiary on that. That doesn't go through probate. That's true. It doesn't go through probate for routing purposes, but it still ends up on your estate inventory, and most of the costs and the fees that are associated with probate are based on your gross taxable estate. The one asset we get to exclude from anything probate related, and it still goes on the inventory, is life insurance with a direct beneficiary. But even that I find to be misunderstood, because if I have life insurance and it pays to my wife and I pass away and she passes away 45 days later, that's cash. She received that cash and is now part of the estate. So a properly drafted and funded trust is the most efficient, I'm going to say best way to avoid probate in our state, especially if you own a home, especially if you have assets that are worth more than $500,000-$600,000. A lot of people don't recognize that probate can be $15,000-$20,000. A trust is a heck of a lot cheaper than that.
Let's talk a little bit about the different kinds of trusts. I think I've read a little bit about revocable living trust and irrevocable trust. What's the difference and advantages and disadvantages?
Sure. I mean, you have the obvious. One is irrevocable, which means you can't revoke it, which is actually not true. It just means it's open. But
it's not true.
Typically speaking, the way I describe the differences is we use irrevocable trusts for very, very specific purposes, right? So if we're doing, some Medicaid's asset protection, we would use a specific irrevocable trust for that. If we're using we're trying to do some estate tax mitigation, which we'll get into further, and we're using life insurance to help pay down some of those estate tax bills. We're getting something called an ILIT, an irrevocable life insurance trust. A revocable trust, on the other hand, is just your, I'm not going to call it run-of-the-mill because they're not run-of-the-mill, but it's your utility plan. It's there. It's a will substitute. It's designed to get your assets from point A, that's you, to point B, whether that's your spouse, whether it's your children, some other beneficiary. I deal with people all the time who don't have kids. They have stuff too. They have needs too, right? So it's designed to get those assets from point A to point B. The key is, if all of your assets are in a trust or have a direct beneficiary, we don't need to open probate to move your assets from point A to point B. If we don't need to open probate to move your assets to point A to point B, we don't need a judge. If we don't need a judge, we don't need probate. If we don't need probate, all those fees don't apply. So the key, and I'm going to throw it back to Loren on this one, the key is, and this is why the team is so important, your financial advisor, your banker, your CPA have to also understand what you're doing, because if your financial advisor doesn't understand what you're doing on an estate plan side, your beneficiaries are going to be wrong, not necessarily, but they could be wrong. And if those beneficiaries are wrong, that might trigger probate, which defeats the entire purpose of comprehensive estate plan.
Yeah, a lot of times when people come to us for the first time, we talk about a legacy plan. Maybe they've worked with an attorney to create an effective legacy plan, but then I'll dive deeper into the question. I'll say, okay, you have a revocable trust. I don't see it anywhere on your accounts. How are you actually using this revocable trust? And many times they'll come back and say, I don't know. I got this list of instructions from my attorney. I don't know how to interpret it. I haven't got a lot of assistance from my attorney as far as how to use this after it's been created. And then we have to dive further into how are you going to actually use this? And so a phone call to the attorney, looping in the client, typically is a good way to go, which is why I appreciate working with you, because it is pretty clear what they should be doing afterwards, and you're just a phone call away, and we're both on the same page when it comes time to it. The revocable trust is the most common type of trust that you do work with. One of the misconceptions of the revocable trust, a lot of people think that having assets in the trust will help them protect against Medicaid. But in fact, that's not the case. So in that particular instance, if somebody's looking for that Medicaid protection, what are they doing?
We would need an irrevocable trust. And you need to understand, you talk to a Medicaid specialist, because there's a lot of rules. And when you send assets to an irrevocable trust for a Medicaid purpose, there's going to be a look back period where you're not eligible for Medicaid. And that look back period is directly correlated to how large of a gift you are making to that trust. Basically, you take that gift, you divide it by the Iowa average for medical assistance. There's a number they publish. I'll be honest, I haven't looked at it in 2025. I don't know what it is. But then you take that, and that's how many months you are ineligible with a maximum of 60. So it's important to do that in a plan and not just sort of ad hoc, because I have seen situations where people have transferred assets and then they've waited, and then they've transferred some more assets. Well, you're just restarting that clock. You're much better off just getting it all moving at the same time.
We've got a lot more to talk about when it comes to planning your legacy next. Welcome back to Retiring Today. We're talking about protecting your legacy as you plan for retirement. Hi, I'm Molly Nelson here with Loren Merkle and estate planning attorney Charlie Bottenberg. And Loren, you sit down with people every single day. You talk about their futures. And one thing as you get towards that legacy pillar of the planning is they talk a lot about their kids and grandkids and how to effectively and efficiently pass on money to them.
And just recently I sat down with a family. We were putting together their Retire Secure roadmap, and we were talking about their legacy plan. And they said to me, Loren, we are not good with money. Our kids are not good with money. We are concerned if they were to receive all of this money. What if we become incapacitated while we're alive? What happens when we pass away? How do we protect against that? And so then we went in to talk about some particular strategies, but it was top of mind. How do they protect their kids? And then even going a generation further, their grandkids.
Yeah, and that's where Charlie comes in, right? Because you can start that conversation, but there's some legal things that an attorney needs to put in place. And a lot of times, Charlie, that can be some specific wording in the trust that can meet the needs of a couple like the one you just talked to.
Yeah, absolutely. It's gonna be wording in a trust of some sort, whether it's a testamentary trust inside of a will that goes through probate, or whether it's inside of their revocable trust that does not. But a lot of people are just unaware. We have a ton of strategies on how to mitigate that, right? I mean, if you're not good with money, your kids aren't good with money, that tends to happen a lot because your kids learn from you. And if your kids aren't good with money, or even if you're great with money and your kids are terrible, there's lots of ways that you can set up an asset protection trust that doles out money slowly. You get to name what it pays for, what it doesn't pay for, and way more importantly, I think you get to name who's making those decisions. Do you have a trusted family member who could do that stuff for you? A lot of times you don't. Okay, well, we can look at a bank trust department or other corporate trustee who can do that. They can work with your financial planner to continue to manage your funds the way that you have, because you have a lot of great context and connectivity between your financial planner and you because of your goals that you've talked about. So that person can still be involved, but we can make sure that those funds are protected for a rainy day, so that if your kid has special needs or they have a spending problem, or even they're in just a rocky relationship and we don't really trust your in-law, we can go a long way to make sure those assets that you worked so hard in your life to accumulate stay in your family and move down the family tree, whether that's your kids, whether that's your grandkids, whether that's nieces and nephews, whatever it is that you're trying to do.
And I'm glad you said tricky situations or in-laws, because we do know that there's a lot of blended families out there. You work with a lot of people who maybe are on a second marriage, or maybe they just have a long-term partner and they're concerned about maybe that partner's children inheriting some of their money, and maybe they want to put some parameters around that.
That is a big concern, but the other thing I see in that type of situation is there's a lot of resistance to talk about it when they're in a blended family, right? Maybe they got married 5 years ago, they both have kids on that side, and they have not yet brought it upon themselves to have that conversation. Honey, what happens if you were to pass away? Where do you want your assets to go? Your 2 kids? Do you want some to stay with my 3 kids? And vice versa. And that conversation needs to happen, because if you're not both on the same page, or at least if you haven't had that conversation, then how do you know what plans to put in place to make sure whatever you want to have happen is actually going to take place? So the blended families, you're right, there's a lot more blended families than there ever have been before. It's a very common circumstance. There's a lot of different ways to tackle what it is that you want to do, but a conversation should be the first start. Decide what you want to do, and then people like Charlie can put that in place.
And the great news is, I'm awesome at being awkward in a meeting and being the one who sticks their foot in their mouth and asks.
So if they haven't talked about it, you're going to bring it up.
It happened to me yesterday. Is this your kids? Is this your kids? Is it our kids? Heck, sometimes he has a couple of kids and she has a couple of kids and they have a couple of kids.
Sure,
right?
of course.
Right.
Right.
And then maybe one of the other, the bonus parents is independently wealthy, and there's a sense that we need to get more over to the ones who aren't going to have it. I don't know. The goal, and Loren, you put it perfectly, you have to have the conversation. Because at the end of the day, if our job is to make sure those assets get where they're supposed to go, we really need to know what that is, because I'll make something up, but it's probably not what you're going to want. Right. And again, to go all the way back to the previous conversation, the state of Iowa has made something up. I can pretty much guarantee you it's not what you want.
Right.
And that's the value of working with a professional, right? So you can sit down and have conversations at home, but you don't maybe know all the questions to ask. I mean, Charlie, you've helped people set this up now probably hundreds of times. So you know exactly what questions to ask. You also, I'm sure, have been there when people have had to kind of work this out in real time. And that's part of the psychology of what you do, is kind of help them do that, even when it gets a little tricky.
That is why they call us attorneys and counselors at law, right? A lot of this job is not necessarily logic-based. It's how do we integrate all the beneficiaries, all the people, all the personalities, which, by the way, the attorney doesn't know on the front end. right? Very important that we have that full disclosure. But, you know, if you have 3 kids and you're picking roles for people, well, sometimes we put the other kids in as a backup, not because we want them to be the backup, because that means that even more terrible things have happened. But nobody else wants to pick up the plan that the parents put in place, and you're just not in it. Well, why am I not in anything? Did mom and dad not care about me? Well, the answer to that, of course, is no. Well, I hope it's no. Generally speaking, the answer to that is no. And so we just got to make sure that we're working all those people in. But a lot of that stuff is things that a client's not going to understand, which is why, you know, we exist to have those conversations.
And when you say not everybody's in it, are you talking about from a control standpoint, like a trustee, somebody who has a decision-making power once the parents pass away, or are you talking more from a beneficiary and receiving of assets?
I mean, it's both. I've had lots of clients, you know, write children out for various reasons, some good, some bad. But, you know, if let's say it's just your standard 1950s husband, wife, 3 kids, white picket fence, 2 dogs, whatever, right? You got 3 kids. Okay, well, you know, you don't have a role for every kid as primary.
Right.
But you can make sure that every kid has a role. Maybe it's a backup, maybe it's a co-backup, maybe there's something. But at the end of the day, when the inevitable happens and we're dealing with the really bad emotions, which, by the way, that's my least favorite part of the job, but it's also my most important part of the job, we want to make sure that all of those kids understand and feel the love that you have for them that you're trying to pass on. And again, it's not one of those things that on paper logically makes sense, but we're just trying to make sure that we're covering all those bases, because emotions are a real thing too.
We'll continue talking about securing your legacy with power of attorney and medical directives next. Welcome back to Retiring Today. We're talking about planning for and protecting your legacy. I'm Molly Nelson here with Loren Merkle and estate planning attorney Charlie Bottenberg. Next up, we want to talk about power of attorney and medical directives. Of course, top of mind for a lot of people as they're heading into retirement, Charlie.
Absolutely. Incredibly critical documents as part of your estate plan. They come in multiple varieties, but really we're talking about a medical power of attorney, which for most of us in Iowa is going to include what we call a living will or advanced directives. And then we're talking about a financial power of attorney. I think most people can tell the difference. Medical power of attorney is about medical decisions. Who's going to step in? Who's going to make those medical decisions for you if you can't make your own? Living will is, in essence, stating if you're on a ventilator, you're on a feeding tube, you have no brain activity, and the physician is fairly certain you're not going to, more than fairly certain, I would hope, very certain that you're not going to recover, you know, allow you to go naturally. But what a lot of people don't know about medical power of attorney, it also lets you move medical records from point A to point B. And there's a couple of choices you have to make about being left on a ventilator as part of organ donation, and also who can move medical records and what access or not access do they have. So again, incredibly critical documents. Financial power of attorney is probably even more critical. The reason why is there are some default provisions for healthcare power of attorney in our state. There are not for financial power of attorney. So on a financial power of attorney, you get to pick who's going to make financial decisions for you if you can't make your own. The scenario is generally you're alive, but you're incapacitated, whether that's mentally or physically, and you can't handle those decisions. You get to pick what decisions they have control over, and just as importantly, when they get to make those decisions. Is this document live the second we sign it? Or do we need a doctor's note that says, yes, you need to invoke the power of attorney? So again, any estate planning package or any estate planning setup that you have critically needs medical and financial powers of attorney. I dealt with a situation a while ago, business owner, he was the only one on the business, no financial power of attorney. He had a stroke, couldn't make payroll because he was the only one who was authorized to do payroll. A little bit of really, really basic front-end planning could have made his wife, who also worked in the business, the vice president of the company or his financial power of attorney or something that would have been able to handle that. So needless to say, if we need to seek guardianship and conservatorship, which are the court versions of financial power of attorney and medical power of attorney, it's a heck of a lot more expensive. It's a heck of a lot more traumatizing on everybody to have to go through that process. It's easier just to pre-plan a little bit.
And do you find that it's difficult for people to decide who to name the power of attorney and medical power of attorney?
It really depends. And oftentimes what I will do is I will break them apart into 2 very, very separate conversations. And I say, if you were in a car crash and you couldn't make your own decisions, other than your spouse, which is where most people start, but maybe you're not married, or maybe it's a second marriage and you have adult kids. That's always a fun one. Who would you want making those medical decisions for you? And oftentimes the client has somebody in their family who's in healthcare, but oftentimes the client also has somebody in their family who really struggles with emotional decisions. It's maybe not as much of a we're picking this person as maybe we're putting this person, out of a spot that they're not going to be able to handle. Financial is the other way. Maybe they're that same person who's emotional and can't handle those decisions, is great with finances and is very organized and can handle all of that. So it's really important to have those conversations, because a lot of people, and I fully support this as a firstborn child, a lot of people just pick their oldest kid. Well, maybe that's not the right choice. Maybe it is, but the key is we got to make sure the plan fits the clients and it fits really who those personalities are.
And then once they make their selection on who they're going to have as their power of attorney, do you find that it's good for them to communicate to that individual or individuals, hey, here's what I decided and this is what that means to you?
Absolutely. Because here's the deal. Loren, if I'm your financial power of attorney and I'm your medical power of attorney and you're in a car crash and I don't know, makes it kind of hard for me to know I got to go do that job. Right. And if I don't have the document, right, that's the second question that you didn't ask. Do they need a document? Maybe, maybe not. They at least need to know where to get it, whether that's in your office, whether that's your attorney's card so they can contact you. But that's great. If I'm power of attorney and I don't have the physical document, guess what? I'm not power of attorney, because the hospital's not just going to take my word for it. The bank is sure not just going to take my word for it.
Yeah, so you'd recommend the power of attorney also have that physical document. Does it need to be an official notarized document, or can it be a copy of the official document?
So the original document will be notarized, right? A scan or a copy is normally good enough in most situations. There are some spots where you need an original financial power of attorney, but they're usually pretty few and far between unless we're dealing with real estate. So whether it's get them a copy or at least let them know where they can get a copy, one of those two things is critical. Yeah.
Let's move on to taxes, guys. The last thing we promised to talk about. That was a big sigh, a big deep breath over there.
He's ready to go.
He's ready to go on taxes in the last couple of minutes here. People sometimes get concerned about estate taxes, Charlie, but there's definitely some stuff they need to know before they get concerned.
Yeah. Well, so right now you need to understand that each individual in our country has a $13.99 million, that's just shy of $14 million federal estate tax exemption, which means if you pass away as a single person with less than $14 million, you have no estate tax. Under most normal circumstances, you're able to use your spouses as well. So if you're a couple and your estate plan is set up even remotely correctly, and you're worth less than roughly $28 million, again, you don't have an estate tax problem. What people don't necessarily understand is that's all part of the Tax Cuts and Jobs Act of 2017. All of those provisions are expiring at the end of 2025, unless Congress and the president should extend them. We're expecting them to eventually be extended. But until it's happened, from my personal opinion, you plan like it's not, because that's the safe way to do it, those thresholds are coming down in half. So in 2026, most people are projecting about a $7 million exemption per person and about a $14 million exemption per couple. That's relevant because if you find yourself in a situation where you're between $14 and $28 million in assets as a couple, you have options that could expire at the end of this year. Could, because we don't know. But that's why it's critical to talk to your financial advisor, your attorney, your CPA, and to look at that. If you're under that level, you don't have an estate tax problem currently. Obviously, Congress could always change the law. But generally speaking, that's kind of estate tax amendment.
And that's why it is important to work with a team that's watching this legislation for you so that you don't have to keep track of it and they can apply it to your situation, because everyone's situation is different. A Retire Ready call is a great time to talk about what's on someone's mind.
And things are constantly changing. And one of the hardest parts about retirement planning is just simply getting started, which is why I like the Retire Ready call so well, because it is a simple way to get custom information to your questions, custom answers to your questions, and you can get started building your Retire Secure roadmap.
You can schedule a Retire Ready call right now by going to retirereadycall.com. There's a calendar there. Choose a time and a date that works for you, and you can talk about what's on your mind in a low-key, low-pressure conversation with a retirement planner. This is Retiring Today, and we thank you for watching. If you like this video, click here for more great content. Don't forget to subscribe to be connected with others just like you who are looking for engaging and entertaining retirement strategies.